Welcome to today's webinar. We'll be hearing from a member of Jackson Lewis team about legal updates. And I love this heading. What just happened? I think many of us feel that way. The past months have been pretty intense for us across the country. So we're going to talk about top labor and employment law developments that may have been overlooked during the COVID-19 pandemic. Very easy to do with so many moving parts. Our presenter is Donald C. Works III. He is a principal in the Orlando office of Jackson Lewis. He practices employment law representing management. So he's on our side, if there are sides. He graduated from Auburn University with a Bachelor of Science in Personnel Management and Industrial Relations. So he's also on the HR side of things, and I love that, of course, being in HR. And also his Juris Doctorate from the University of Miami. He's a past president of the Greater Orlando SHRM and the HR Association of Broward County, and he holds both his SHRM SCP and his SPHR certifications, and has repeatedly been recognized by peers and clients alike in the publications Best Lawyers in America and Florida's Super Lawyers and Chambers USA as well. So Don, thank you for being here. As always, I'm looking forward to hearing about legal updates, so thank you.
Well, thank you so much for the kind introduction, Sandy, and good afternoon, everyone. Well, as it says on the slide here, the past 6 months will certainly be a time that we'll not soon forget. This COVID era has kept us all extremely busy trying to figure out which end is up in terms of the law, how do we handle issues with our employees, and just generally, how do we get back to some sense of normalcy in the workplace? And unfortunately, the issues with regard to COVID are not quite over yet. In fact, most recently, there have been, in the last couple weeks, some changes to the Families First Coronavirus Response Act. And you can see in the next slide, actually it's 2 slides forward, there was a case that was decided by the United States District Court from the Southern District of New York in August, where the court struck down 4 key provisions in the Department of Labor's regulations implementing the Families First Coronavirus Response Act. So this happened just 4 months after the regulations went into effect, and only 5 months before they're set to expire. But in its infinite wisdom, the court decided that some key provisions were invalid in the regulations, that they were void for vagueness and other reasons. Specifically, they struck down the definition of who would qualify as a healthcare provider for the exemption from the law. They struck down the exclusion of benefits to employees who employers didn't have work for them. They struck down the requirement that employees get employer consent to take leave on an intermittent basis under the law. And finally, they struck down the requirement that employees have to provide documentation before they take leave under the Families First Coronavirus Response Act. So needless to say, these were some really key provisions in the law that were struck down. And as you can see in the next slide, the decision left employers, including I'm sure many of you, to surmise or guess as to what the answers to questions might be, like who are healthcare providers who might be exempt under the law? I've got employees out on furlough, or I don't have work for them. Do I have to also give them paid leave under the law? And finally, what employees have to provide in the way of documentation to support the need of leave. So here we are just a few months into the pandemic, the court strikes down part of the key regulations, and we're already guessing as to what we have to do under the law. So fortunately, the Department of Labor came to the rescue pretty quickly after the Southern District of New York struck down the regulations. And on September 11th, they posted revisions to the regulations under the Families First Coronavirus Response Act. The revisions do a number of things. First, they reaffirm the requirement that employees can only take leave under the law if work would otherwise be available to them. So in other words, if they're missing work due to a furlough and you don't have work for them, and not for one of the reasons under the FFCRA, then they're not entitled to leave or pay under that law. The new regulations also reaffirm the requirement that they have to, that is, your employees have to have your approval if they're going to take leave under the Families First Coronavirus Response Act on an intermittent basis. They also clarify that employees have to provide documentation to support the need for leave under the law. And finally, and maybe most importantly, they revised the definition of healthcare provider so we can tell who in the healthcare field is actually exempt from the requirements of the law. And what they did is they said a healthcare provider is anybody who is defined as a healthcare provider under the Family and Medical Leave Act, that definition's been around for years, or who are employed to provide diagnostic services, preventive services, treatment services, or other services that are integrated with and necessary to the provision of patient care, which if not provided would adversely impact patient care. So as you can see, that's pretty broad. Any services that touch on patient care and persons providing those services will be included within this definition of healthcare provider and therefore within the exemption under the law. So here it is, just a short time into the pandemic and into our having to deal with the regulations. Part of them are struck down, they're immediately revised. So here we are trying to relearn the law all over again with new terms here in September. So in addition to dealing with that particular coronavirus issue, I'm sure many of you are dealing with issues about return to the office. So as you can see in the next slide, I'm sure you're running into issues about, the employee who's afraid to return, the employee who refuses to return, the employee who wants to stay out because they're better off on unemployment than they would be coming back. And all of these are presenting difficult issues for you as employers. You have to look at each situation individually in this regard. First of all, employees may be afraid to return for different reasons. First, if they're in a vulnerable population, for example, due to age, disability, a medical condition, or pregnancy, we have to consider each of those situations separately. There's nothing in the law that requires you to make an accommodation for persons of a particular age. If you're making accommodations, however, for all employees, and particularly younger employees, then you have to make the same accommodations for older employees. You can't discriminate based on age, is basically what it comes down to. But age is not a per se, I guess, ticket to unlimited accommodation under the law. On the other hand, if somebody has a disability or a medical condition, or they're pregnant and they have a medical condition relating to pregnancy, you as employers are having to grapple with this issue of what kind of accommodation could we make for them when they're afraid to return due to one of those conditions. And one of the forms of accommodation that, of course, is coming up, because we've been doing a lot of it lately, is working from home. And many employers are allowing that as a reasonable accommodation. So with these vulnerable populations, you've got to look at each individual circumstance separately and decide whether an accommodation is doable and if it's required under the law. Now, some employees are afraid to return to work because they're afraid of potential exposure in the workplace. It has nothing to do with them being in one of the vulnerable populations, but they're just afraid of being exposed to COVID in the workplace. If you are thinking of letting somebody go on that basis, that they refuse to come back because they're afraid of exposure, be cautious, because OSHA requires you to maintain a workplace that's free of recognizable hazards. And if an employee complains and says they don't think your workplace is free of a recognizable hazard, COVID, then they may have protection under OSHA from retaliation. So you want to be cautious about taking any adverse action against an employee who's afraid to return because of potential exposure. Moreover, if they're speaking on behalf of themselves and others with regard to the workplace conditions, they may be engaged in protected concerted activity under the National Labor Relations Act, and you can't retaliate against them on that basis. So you see these return to office issues are not quite so simple. You can see in the next slide, we've got other employees who just outright refuse, and the question, what are you going to do with them? Do you have to provide them leave? Maybe require that they take existing PTO or that they have accrued? What about, do you have to give them paid leave? Well, that'll depend upon whether they qualify under the Families First Coronavirus Response Act. So, and then some employees who say they make more money on unemployment. Well, obviously that in and of itself is not a good reason to refuse to return to the office. So in sum, the past 6 months have been extremely difficult dealing with COVID issues, and they're not over yet. As you can see, we've got changes under the Families First Coronavirus Response Act, and we're dealing with return to work issues. Let's put those aside for a moment, however, and turn our attention to what I really intended to be the primary topic of today's webinar, and that is labor and employment law developments that you might have missed over the last 6 months or so while you were focused on COVID issues. And the first such development that you may have heard about on the news is a very significant one, and that is the Supreme Court deciding that Title VII of the Civil Rights Act of 1964 does in fact prohibit discrimination based on sexual orientation and transgender status. You can see in the next slide, the decision that I'm talking about is Bostock versus Clayton County, Georgia. There were actually 2 related cases that were all taken up together by the court. And the court held that when Title VII prohibited discrimination based on sex, that term sex should be interpreted to prohibit discrimination based on sexual orientation and discrimination against transgender claimants based on their transgender status. And a quote from the decision is, when an employer fires an employee for being homosexual or transgender, it necessarily intentionally discriminates against that individual in part because of sex in violation of Title VII. The court also said that the plaintiff's sex need not be the sole or primary cause of the employer's adverse action for Title VII to apply. So if it is a reason that an employee was let go or demoted or any other adverse action was taken against the employee, then that alone is enough to find a violation of Title VII. So this is a very, very significant development. As you can see in the next slide, there are quite a few implications. Many state and local laws already prohibited discrimination based on sexual orientation or gender identity. So, if you're in one of those jurisdictions, it doesn't necessarily make a big change. But in other jurisdictions where that wasn't the case, we had the EEOC taking the position that Title VII covered these characteristics, whereas the courts were saying it did not. So the US Supreme Court has now resolved that issue and aligned the EEOC's position with court decisions or court findings. So this is probably going to lead to increased litigation under Title VII in federal court, and possibly additional litigation being brought by the EEOC, now trying to underscore the point that was made and that they believed for a long time, that Title VII prohibits this type of discrimination. So what can you be doing to adjust to this change? First of all, if we go back to the prior slide, you should be looking at your policies to make sure that they expressly prohibit any type of gender identity or sexual orientation discrimination or harassment. of course, investigate complaints from the LGBTQ plus community, and train your management and employees on the prevention of this type of discrimination. They need to understand that these are, in fact, protected characteristics. So that's the first significant development that's occurred post-COVID in the labor and employment field. The next one I'd like to talk about is the United States Department of Labor's rule on the fluctuating work week pay method. And to get into that, let's first talk about what this FWW pay method actually is. It's actually an exception to the standard way of calculating overtime. And I'm going to take this slowly just to be sure we're all clear. We're dealing with non-exempt employees who are entitled to overtime under the law. And under this method of paying them, you would pay them a fixed salary for all hours that they work in the work week, no matter how many or how few. And the employee's hours must regularly fluctuate from week to week. So you're going to, whether they work 30 hours or 60 hours, you're going to pay them that fixed salary. Now, you have to be sure that the fixed salary is enough that when it's divided by the number of hours worked by an employee in a work week, that it equals at least minimum wage, that it never goes below minimum wage. If you're able to do all those things, then overtime that's due is only 1/2 of their regular rate for the hours worked over 40. It's not time and a half. Now, one of the things, this is traditionally how the fluctuating work week method of payment worked. And one of the things that we have always advised employers is that you should have a clear written understanding and acknowledgement that that's how the employee is being paid in advance before you use this method of payment. So you need to understand that because their hours vary from week to week, their regular rate and their overtime rate are also going to vary from week to week. So it's got some administrative complications. All right, where did the issue arise? Well, many employers were using this method of payment prior to this year. And we'll look at a typical example of how it works in the next slide. Let's say the employee was guaranteed a fixed salary of $780 a week for all hours worked, and the employee worked 60 hours. To determine their regular rate of pay, you would divide the 780 by 60. And you see that in that particular week, the employee's regular rate of pay is $13 an hour. Their overtime premium is 1/2 that rate. So 1/2 of 13 times the 20 hours of overtime, that's the 20 hours above 40, equals a total of $130. So their total pay for the week would be $780 plus $130 equals $910. So you can see what's happening here is that the more hours that an employee works in a work week, the lower their regular rate becomes, and therefore the lower the overtime rate becomes. I mean, it's always going to be half-time, not time and a half, but it goes down depending upon what the regular rate is. One thing that employers have done for years is when you have employees who perhaps are out in the field and they're abusing overtime, trying to make a lot more money. If you go to the fluctuating work week and they're putting in excessive hours, they quickly figure out that the more hours they work, the lower their overtime rate or their regular rate becomes, and therefore the less overtime they're actually making. So it discourages excessive overtime by employees. So that's one of the reasons it's used. The other reason is obvious. You're paying half-time rather than time and a half. Perhaps the downside is that it is a guaranteed salary. So in a work week where the employee, for whatever reason, only works 30 hours, you're still going to have to pay them the $780 a week guaranteed salary. All right, so that's the typical example and where we were going into 2020. Where did the conflict arise? Well, in 2008, the Department of Labor put out a notice of proposed rulemaking saying that if an employer paid an employee compensation in addition to the guaranteed salary, that was okay, that was compatible with this method of payment. In 2011, when under the Obama era DOL, the final rule came out, they rejected that proposal, and they said that premium payments of any type destroy the fluctuating work week method. In May of this year, the DOL came out with a new final rule, holding that payments in addition to the fixed salary were compatible with the use of the fluctuating work week method of compensation, and that those payments have to be included in the calculation of the regular rate as appropriate under the FLSA. Since that DOL rule came out, there's already been one decision from a Circuit Court of Appeal, as you can see in the next slide, in Thomas versus Bed Bath & Beyond, a Second Circuit case from June of this year. They agreed with the final rule and held that if an employer gives bonus payments or premium payments or other additional pay to an employee being paid on the fluctuating work week method, that's okay, as long as those things are included in the regular rate of pay. And they also held that the fluctuating work week method did not require hours to fluctuate above and below the 40-hour week. So in other words, they're saying that if you have employees who are always working over 40 hours, you can still use this method of payment. And finally, they said, if you make a mistake from time to time, as long as you fix it later on, that doesn't destroy the guaranteed salary basis or the fluctuating work week method for paying your employees. So these are some very positive developments for employers that want to use the fluctuating work week method of payment. And the next slide, you can see an example of how it might work, where some payments in addition to the guaranteed salary are made. So we have the same employee who is guaranteed that salary of $780 a week also gets a $20 premium anytime they work a night shift. In the particular week in question, they work 60 hours, again, just like in our example before, but they also work 6 shifts that are night shifts. So their regular rate's going to be the $780 salary plus $120 in the night shift premiums divided by 60 hours in the work week makes $15 an hour. So you can see the regular rate has gone up here. Their overtime premium, which is halftime, also goes up. And for the 20 hours of overtime, they now get $150. So their total pay for the week is the $900 plus the $150 for overtime, or a total of $1,050. So in accordance with the DOL regulations, the shift premiums included in the regular rate of pay, the overtime premium is increased, and the employer is allowed to use the fluctuating work week method of payment, even with that additional payment above and beyond the guaranteed salary. So what are our takeaways here? The first one is you need to be careful. This is not a straightforward method of payment. As you could see, the examples are pretty specific, and keep in mind the employee's regular rate's going to vary from week to week. So you may have a guaranteed salary, but every week the hours vary, and you're going to have to, they still have to keep a record of hours worked because they're non-exempt employees, and you are going to have to calculate the regular rate each and every week and then come up with the new overtime premium and make sure they get that. So it does require careful administration. If you decide to go down this road, obviously you want to work with Alpha staff and your legal counsel to evaluate whether it's appropriate for your workplace and implement it in accordance with the law. All right, another development in the area of pay is a new DOL rule on the regular rate of pay. How do we define the regular rate of pay? Well, generally, the regular rate includes all compensation that's earned by an employee for their services during the work week. In January of this year, the DOL clarified whether or not certain benefits have to be included in the regular rate of pay. And they specifically said, as you can see here, that vacation, holiday, sick pay, or other forms of paid time off do not have to be included in the regular rate of pay. You can also exclude bona fide meal periods. Now, what do we mean by that? They have to be at least 30 minutes long, and they have to be uninterrupted. So if you interrupt an employee during their meal break, ask them a simple question, that destroys the meal period from being a bona fide meal period, and it cannot be excluded. That time worked has to be included in calculating the employee's regular rate of pay. Other things you can exclude would be reimbursement for reasonable expenses, similar payments that are really for the benefit of the employee that you can see here, show up pay, contributions to a benefit plan, like they have something taken out for the 401k plan, voluntary premium payments for insurance, or discretionary bonuses. Now, that last one on the list is one that causes a lot of issues with employers. If you go to the next slide, you can see this issue with bonuses and the types of bonuses that can be excluded from the regular rate and those that can have to be included. Specifically, if a bonus is a discretionary bonus, then it can be excluded. So when we say discretionary, we mean they're paid at the sole discretion of the employer at or near the end of the period to which the bonus corresponds. So spot bonuses, severance bonuses, special bonuses for overcoming a challenge, employee of the month bonuses, or other similar compensation, referral bonuses for referring employees to your company. Those can be excluded because these are all discretionary. Non-discretionary bonuses, things that are linked to performance, productivity, quality, or accuracy, commissions, all of those have to be included when you calculate the employee's regular rate of pay. So if you're paying those types of bonuses, and let's say you're paying them quarterly, you have to spread them back over the work weeks in which they were earned and calculate the regular rate of pay, paying any additional overtime that must be due to the employee for that period. I guess the one thing that always comes up in this area, it seems, are holiday bonuses. And there have actually been some opinions by courts, and the DOL at one time took the position that a holiday bonus was a non-discretionary bonus and had to be included in the regular rate if it was paid year after year after year and employees came to expect it. I would submit to you that that's not the case. I think that that's not the law today, really. You know, if you promise it at the beginning of the year, then I would say it's non-discretionary and it better be included. But if at the end of the year, out of the goodness of your heart, you feel like giving everybody a holiday bonus of some amount, typically that would be discretionary and does not have to be included in calculating the regular rate of pay. So you can see that the DOL in the area of pay has really helped us out in two respects. They've first helped us understand better the fluctuating work week and whether additional payments can be made over the salary, how it works. And they've also better defined for us what items need to be included in an employee's regular rate of pay. So not to be left out of the action, the Department of Labor is not alone in taking action. The EEOC has also been busy over the last 6 months. And in particular, as you can see in the next two slides, the EEOC has issued ADR protocol in early July of this year. And ADR is alternative dispute resolution, for those of you all who don't know. Things like arbitration, mediation, conciliation, these are all types of ADR, as opposed to going to court. So the EEOC has announced 2 pilot programs to expand their mediation program and increase the effectiveness of their conciliation process. Now, those of you who have had the pleasure of working with the EEOC know that sometimes they would offer mediation as an option up front when a charge was filed. And in other cases where they find cause, they have to, actually under the law, attempt to conciliate the issue between the parties. Typically, their conciliation effort consists of them telling you what full relief would be under the law for the employee. And if you pay it, then it's over. If you don't pay the full amount, there's no negotiating. That's the end of the story. So that's how it's worked in the past. Under these 2 new pilots, you can see first in the next slide, the conciliation pilot, the EEOC said that there's a single change to process to drive accountability. Honestly, we're still trying to figure out what that single change might be. For example, they said that conciliation offers must be approved by the appropriate level of management before they're shared with respondents. Well, we've always assumed that that was done before, but apparently it wasn't. So what appropriate level would that be? That's probably higher than the local regional office. It probably has to go to headquarters to be approved. I think the idea here is that perhaps full relief is not something they're going to require in each and every case in order to resolve the charge. They've also made a commitment to communication where they're saying that during conciliation, they will share with you the facts that were underlying their cause finding. Why did they reach a cause finding? That could be very, very helpful. They'll also allow the charging party to participate so that, for example, if the charging party is willing to take less than full relief, then maybe conciliation could be successful. So this is a new pilot they're trying in the area of conciliation. In the next slide, you can see that the pilot in the mediation front, as opposed to conciliation, basically the change here is they're going to allow mediation for basically all types of charges except for systemic charges. So class and systemic charges probably won't go to mediation, even though there is a change here. But significantly, they're going to allow for mediation throughout the investigation. In the past, what they would do was they would ask you up front, do you want to mediate? And if you said no, they said, okay, send me your position statement. We'll begin investigation. End of story. No opportunity for mediation after that. Well, now under this pilot, you will have the opportunity to elect mediation at any time during the investigative process before a determination is made. So these are 2 pretty significant changes by the EEOC in the way they're doing things. And these changes should make it a little bit easier for you as respondents, that is employers, to resolve charges of discrimination with the agency.
Hey, Don.
Yes.
I just wanted to ask, in the past, it was the employee's choice as to mediate or not to get it even considered. Is that still the case? Or can the employer require or ask?
The way they have been doing it over the last at least year or so since they set up the respondent portal is they ask both parties whether or not they wish to mediate. Good. And only if both parties agreed would it go to mediation. We expect that will continue.
Good, thank you.
Yeah, the main difference will be that it will be allowed throughout the process, not just on the front end.
Right, got it, thank you.
You're welcome. Okay, so some nice developments by the EEOC. The NLRB has been employer friendly as well. There's been a shift in their decisions. And I guess in order to best understand them, you first need to understand or recall what protected concerted activity is under the law. Basically, the National Labor Relations Act protects employees from retaliating against employees who engage in protected concerted activity. And that is when typically, it's when 2 or more employees act together to attempt to improve their working conditions, or one person acting on behalf of others did something to try to improve terms and conditions of employment. And it would include political speech, any activity that had some connection to the workplace. This does apply to both union and non-union employers, and inside and outside the workplace, including online. So if you take action against an employee or retaliate against them for engaging in this type of activity, that is speaking out in relation to terms and conditions of employment, then you have violated the National Labor Relations Act. Now, under the next slide, you can see what the former standard was. This issue arose because sometimes employees, when they speak out, aren't so nice about it. They use abusive language, they use foul language, they use threatening language. And there was the issue of, hey, you know, if you're going to behave like that, is that something that's really protected under the National Labor Relations Act? Well, under President Obama, the National Labor Relations Board adopted some new tests that basically said, you know, in each situation, you have to kind of look at the total context of the statement. And even if it's threatening or abusive, it might be protected activity, which really miffed a lot of employers because, you know, you're threatening a supervisor and somehow you fire the employee for doing that and you're held liable under the National Labor Relations Act. That did not really seem quite right. So there has been a significant shift this year and a new decision from the National Labor Relations Board involving General Motors. You can see in the next slide. And this decision is going to be applied retroactively to all pending cases where the board would have determined under the prior test whether abusive conduct was protected or whether the employee had lost that protection. This is a huge victory for employers who have had to tolerate really unacceptable behavior by employees for fear of running afoul of the National Labor Relations Act. You can see in the next slide that what's going to happen going forward is the board's going to use the test that was in place before from the Right Line decision in 1980. And they say that the proper standard in deciding where employees engage in abusive conduct and the employer asserts it's discipline is the test. I mean, you've got to look at those situations, and in those situations, the board will have the burden of proving that the employee's activity was your motivating factor in firing them. So in other words, you have an employee who threatens a supervisor because they don't like something about the workplace. It does involve a term or condition of employment. They threaten the supervisor. You fire them for violating your policy against threats in the workplace. The board will have the burden of proving that you fired them for engaging in protected activity. And if they can't prove that that was the motivating factor, then the case is over. Even if they prove that, you can then still establish that you would have taken the same action even in the absence of it being protected activity. So you can see that this gives employers some hope that they can actually enforce rules that prohibit abusive language, foul language, threatening language in the workplace or on social media or on the picket line. So a nice development in terms of what we see as protected activity under the National Labor Relations Act. The General Counsel of the board has also been issuing a number of opinions since COVID. They're in the next two slides. Just quickly, I'll speak on each of them. The Mercy Health case basically said that an employer who unilaterally changed its work from home and attendance policies did not violate the National Labor Relations Act. It did not have an obligation to bargain with regard to those issues, given it was an emergency situation. And in the Larry Peel case, the board general counsel said that an employer could change its attendance policies without bargaining. In the next slide, you can see in the RS Electric Corp opinion, the general counsel said that the employer could impose reasonable notice requirements on the union before the union visited the employer's place of business. And finally, in children's services, the general counsel said that when the District of Columbia closed its schools and laid off employees but gave them temporary work assignments to do COVID testing, that they did not have to bargain over that with the union. So in other words, they could go ahead and change assignments without bargaining. All of this, or these four opinions, are really because we're in the midst of a pandemic, that employers are getting a little bit more flexibility under the law, and they're permitting them to do things without bargaining with the union. All right, so the DOL's made some big pay changes. We've got the EEOC making changes in how they do things in terms of conciliation and mediation. We have the National Labor Relations Board becoming employer friendly, which is a significant change considering how it's been for the last several years. And then finally, I want to talk about the Department of Labor and the Department of Labor's joint employer rule. Now, basically, we have to first consider the history. And if you look at the next slide, you can see that since 1939, there have been some regulations under the Fair Labor Standards Act, that's our wage and hour law, that have recognized that two or more employers could be jointly and severally liable. So that's typically if they had common ownership and control over the employee. In April of 2019, the Department of Labor issued a notice of proposed rulemaking to update the standard on joint employer liability. And then in January of this year, they adopted a final rule that became effective in March. In the final rule, you can see in the next slide that the Department of Labor stated that the proper focus on whether or not two entities would be joint employers would be the potential joint employer's exercise of control over terms and conditions of the employee's work. So if there were two entities and there was a question as to whether one was actually a joint employer, they would focus on whether or not that employer had the potential to exercise control over the terms and conditions of employment. And you can see that that was derived from a Ninth Circuit Court of Appeals decision. And they look at four factors: whether the purported joint employer would hire or fire employees, supervise them, control their work, determine their method of pay, their rate of pay, and whether they maintain their employment records. So they'll look at those different factors. And they went on to say that an entity could qualify as a joint employer only if it actually took action with respect to the employee's terms and conditions of employment, rather than merely possessing a theoretical ability to do so. Well, this got the attention of a lot of different state attorney generals around the country. Why? They're worried about their tax base, quite frankly, because in joint employment situations, they had the ability to go against or after multiple entities to collect employment taxes. If all of a sudden we're making it harder for entities to be deemed a joint employer, then what happens? Well, we have a decrease in our tax base. So as you can see in the next slide, there were a number of different attorney generals who sued from 18 different states, who filed suit to have that final rule vacated. And they claimed some technical violations of the Administrative Procedure Act and said that by narrowing who's considered to be a joint employer, it would harm the states in multiple ways. And they actually said because they'd lose tax revenue, but they came up with some other reasons as well, as you can see here. So what did the court do with this? Well, again, as you can see in the next slide, we have the United States District Court for the Southern District of New York getting into the action, and they ruled in favor of the attorneys general and struck down the more controversial portion of the final rule. And for you to understand what part they struck down, you need to understand that the DOL came at this from two different perspectives. First of all, They said there are two different kinds of joint employment: horizontal joint employment and vertical joint employment. With horizontal joint employment, that's really the traditional scenario where we have two interrelated entities, common ownership and control, that jointly employ a particular individual. With vertical joint employment, on the other hand, they were focused more on a situation like a staffing agency or where you had a subcontractor providing employees to you. And that troubled these state attorney generals because they were going after these staffing agencies and subcontractors. So the DOL said, we're okay with the Southern District of New York said, we're okay with the DOL standard on horizontal joint employment, but they struck down the definition of joint employment with the vertical joint employer test. So they agreed that that final rule would increase enforcement costs, as you can see in the next slide. And they held that the test for joint employer liability was impermissibly narrow. And finally, they held that while the factors demonstrating control were relevant, they weren't necessarily a condition to establishing joint employment, making it easier for states and individuals to prove that two or more entities were in fact their employer and liable to them for various taxes, and also claims that might be asserted under discrimination laws. So the takeaway from all of this, the head of the DOL's Wage and Hour Division has stated that notwithstanding the decision by the Southern District of New York, they believe that the test is correct, that their final rule is correct, and they're going to stand by it. We're still waiting to see whether they will appeal the court's decision. I would say it's highly probable that they will do so. But this is a significant development. The clarification of who is a joint employer was important to many of us as employers, and to see it struck down so readily by a court is a little bit disconcerting. Hopefully we'll get some final resolution of this in the coming months. So looking back over what we've covered today, you can see that while we're still dealing with a number of issues relating to the coronavirus, Families First Coronavirus Recovery Act or Response Act changes, some issues regarding return to work. While all that's going on, we've seen some significant changes with regard to Title VII, the fluctuating work week, regular rate of pay, EEOC ADR protocol. We've seen a shift in National Labor Relations Board decisions. And finally, we've made some progress in the front of joint employer definition. So a lot's been going on. I hope that the last 50 minutes or so has been beneficial to update you, and that you've taken away something from today's presentation that will be of use to you in your workplace. If there are any questions, I'll be happy to try to answer them now. Thank you.
Great, thank you, Don. We do have one question. I'm going to read it. Let's see. Now that companies are starting to require employees come back to the office, if an employee asks to work from home because they have a health condition and are afraid to come back into the office, what should we do? Employee is out of PTO and does not qualify for FFCRA. Can termination be considered for job abandonment?
Well, if it's because of a health condition, you have to consider whether or not the health condition is a disability under the law that must be accommodated. So you can ask the employee to have their physician provide information about what their restrictions might be. And based upon what the physician says might be required in terms of restrictions or accommodation, you make decisions as to what reasonable accommodation you can make. That may include working from home as an accommodation. But in a situation like this where it may be a disability, you should probably work with Alpha staff to properly make the inquiry, the medical inquiry, through the employee to gather information about what the condition is, what restrictions the employee has, and then what accommodations, according to the healthcare provider, might be required. Once you get that information, then you can decide whether you can make that accommodation.
Okay, and I'm guessing that this is in a position where somebody can't work from home. For example, a movie theater, restaurant, you know, things that may be open that require physical presence. And once, let's say they go through the ADA accommodation process and it's determined we can't accommodate that way, then I guess that question is, do we move to termination? I mean,
Well, once you get to that point, and you do so carefully, because this is a very sensitive area, obviously, where you could end up with a discrimination claim based on disability. But if you get to that point where you find that somebody has a disability and they can not perform the essential functions of their job with or without an accommodation, then you can move toward separation.
okay.
But you first have to engage in that interactive process to determine whether an accommodation can be made.
And Don, we have no more questions, but we were chatting prior to the webinar about the cases that you've been seeing. I know in June when you shared with us you expected to see cases that's rung true. Were there any particular ones that stand out that might help our clients to kind of circumvent those same cases?
One, the cases that I've been seeing thus far have been cases directly under the Families First Coronavirus Response Act. And it's not so much that employers haven't followed the act in terms of allowing the time off or paid leave or paying people properly. Mm-hmm. What's happening is that when the employees come back, the employers are dealing with performance issues that perhaps arose prior to the leave. Mm-hmm. And by doing so, it's appearing that they're retaliating. And so the cases we're seeing are retaliation cases under that law, mm-hmm. for the most part.
Well, that's interesting. Mm-hmm. You know, it's such a crazy time. It feels like the Twilight Zone, if people are old enough to remember that series. But sure appreciate your time as always and the information that you shared. I don't see any more questions. I always like to let our attendees know if they do think of something afterwards, be sure to reach out to your HR account manager. You may want to also reach out to our HR Service Center, either or. If you'd like a copy of the presentation, we can get that to you, as well as the SHRM and HRCI credits at our email, hrsc@alphastaff.com, or you could call in, or like I said, speak with one of your, or with your HR account manager. Again, thank you, Dawn. We're looking forward to the next webinar, October 15th. Thank you. Which is Best Practices in Managing Unemployment, presented by our own Pam Nading, whose team has won some great awards for how well we process your unemployment claims. So be sure to attend then, October 15th at 2 p.m. and watch for the recording if you want to share it with some of your colleagues or review it yourself. It should be on our website in about a week to 10 days. So thank you, everybody. Stay safe and take care.
Thank you. Good afternoon, everyone.
Thanks, Don. Bye-bye.
Bye-bye.